our technical first Monday in October. As most of you probably know, it is a tradition for the Supreme Court to start its new term on the first Monday in October. A couple of unusual things about this year. Because of the Jewish holiday yesterday, we of course didn't have class, and although the Supreme Court did start its business on the first Monday in October, they did not, in deference to the Jewish holiday, have arguments yesterday. So their first Monday in October is the same as ours, this legislative Monday, really a Tuesday. A couple of other notable things about this Supreme Court term. This is the 10th year that the current lineup of justices has been sitting together on the Supreme Court, which is really remarkable stability. There's only been one period in the court's history where, in fact, the court has had a longer run than that. There were once 12 years with all the same justices. So what that means is that the sides, the teams, the different personalities are pretty set. And at this point, it's, in addition to talking about what the Supreme Court is doing, we can also talk a lot about who's doing it, because we know a lot about these particular justices and how they interact. So far, the Supreme Court has scheduled 40-some cases that they have agreed to hear so far this term, which means they have room, since they've been hearing 70-some cases in recent terms, for about 20 or 30 additional cases. It used to be, before the current group of justices, the court used to take something like 140 or 150 cases a term. So one thing that has really changed in recent years is the court has really halved its workload, and some would say it made up for it in the length of their current opinions. So what we thought we would do for you today is partially an introduction to the new Supreme Court term, is a couple of things. The Alliance for Justice, as many of you are aware, is a whole group of organizations that sponsors this First Monday program at law schools and other venues around the country, so that all over the country, legal communities are having a discussion in observation of the Supreme Court's new term. The topic that the Alliance for Justice has designated for this year as being a good thing for everyone to have a conversation about is the judicial confirmation process and what's going on with judicial confirmations. We thought, instead of just sticking to that, since this is the beginning of the Supreme Court term, we're going to do a couple of things. Last year's term was capped off in its last week by two extremely big decisions by anyone's count. There was Lawrence versus Texas, the case which struck down state sodomy law, and then there were the two cases out of the University of Michigan on affirmative action. So we thought, before going ahead into the new term, it might be good to reflect a little on some of the really big issues that the court has begun to deal with, but where there are still some open issues from last term. So we'll start with Professor Jason Mazzoni, who some of you may not have met yet. He's new to the faculty here, although well known to readers of the op-ed page and letters to the editor column of the New York Times. And Professor Mazzoni will talk about Lawrence versus Texas.
Thank you. So Lawrence v. Texas is the case that came at the very end of last term. It's the case in which the court struck down a Texas statute that made illegal sexual intercourse, deviant sexual intercourse between members of the same sex. Now, it was widely expected that the court would invalidate the statute. And it was expected that there would be a 6-3 decision. The open questions towards the end of last term were just how far is the court going to go? There was an equal protection argument before the court because the Texas statute criminalized conduct between same-sex couples that wasn't criminalized between opposite-sex couples. So there was an equal protection route that the court could have taken. And the other very interesting open question was, what is the court going to do with Bowers versus Harwood? Bowers was the 1986 precedent that had declared, in the words of the court, that there was no fundamental right to engage in sodomy. So what was the court going to do with Bowers? Well, the court has a vote of 6-3, as expected. There's a decision by Justice Kennedy, joined by 4 other justices, and a concurring opinion by Justice Sandra Day O'Connor, who really sticks to the equal protection ground and would not have turned over Bowers versus Hardwick. And then there's the 3 not-so-wise dissenters who are predicted to dissent from the court's holding. Let's talk about Justice Kennedy's opinion, because it's really very interesting in a number of respects. It's a very elegant opinion, and surprisingly so. And let me say a little more about what I mean by that. Justice Kennedy really to his credit, avoids many of the trappings of constitutional law that the court has generated over the past few decades. So if you look at the opinion, he doesn't start with there being a presumption of a law being constitutional. He doesn't talk about fundamental rights, or is this a fundamental right, or is it some other kind of right. There's no discussion of the level of scrutiny. Is it strict scrutiny, or intermediate scrutiny, or rational, or heightened rational, or some other form of scrutiny. And even though the decision really comes out of the court's privacy jurisprudence, he doesn't talk very much about privacy. Now, you notice that all of those things that I just mentioned have one thing in common. It's that they're not in the Constitution, right? They're things that the court has generated on its own. But Justice Kennedy focuses his decision on something that is in the Constitution, liberty, right? And throughout the decision, liberty, liberty, liberty is really what is discussed. And I think this is very much to Justice Kennedy's credit that he does this. When he gets to talk about liberty, Justice Kennedy defines the liberty interest very broadly. He talks about the interest in being able to define one's own existence and the meaning of life. And so it's a very broad definition. Justice Scalia, in his dissenting opinion in Lawrence, said, why don't you just come out and say that what you're recognizing is the right to engage in, fundamental right to engage in same-sex sodomy. And that was, of course, how the issue had been defined in the precedent of Bowers versus Hardwick. And it's really to Justice Kennedy's credit that he doesn't take that bait, and he doesn't ever define the interest in that way. And the reason really is that it's, I think he understands that to define the interest in such a narrow way is really quite demeaning to the parties, and not really fully recognizing the scope of the liberty interest. So there's this generally defined liberty interest, and Justice Kennedy then takes an interesting step, which is he says, okay, well, you have this law. I want to know what the purpose of this statute is. So he asks the state to define the purpose of the law. And the state's only justification is morality. We don't like this conduct. It makes us feel bad. It makes us feel uncomfortable. And Kennedy says that's not enough. It's not enough to criminalize this conduct on the basis of morality. Now, this is a very interesting move. Justice Scalia has this dissenting opinion in which he focuses in on this point, and he says, well, that means that all laws that are based on morality must be unconstitutional, which of course is not true. Many laws are based on morality, but what Justice Kennedy wants is some other justification. And I think that this point really goes to the question of the court being able to review a statute. If a state can simply stand up and say, the purpose underlying this law is morality. We don't like the conduct. It makes us feel uncomfortable. It really precludes the possibility of judicial review. There's really nothing that the court can say in response to that kind of claim. So Kennedy, quite rightly, wants more. Now, so morality isn't going to do it. You need some other kind of injury or purpose behind the statute, and the state doesn't supply it. So Kennedy says the law is unconstitutional. In a sense, Kennedy's opinion revives a very old idea. It's the idea that individuals and the people precede government. Right? Now, we talk about this a lot when we talk about the national government. You know, the people came before the government, the national government. But it's not an idea that is talked about very much with respect to the state governments. It's an idea that's really derived from John Locke, that government is limited. All government is limited. When people get together and create government, they give up certain things, but they don't give up everything. And this is really the tradition that Justice Kennedy is drawing upon. He doesn't cite Locke specifically, but it is a Lockean idea. And those of you in my legal history class know that Locke was highly influential at the time of the drafting of the Constitution. So it's this idea that a government in general is limited. And you say, well, where is that idea in the Constitution? And the answer may be that it's in the Ninth Amendment. Right? The Ninth Amendment is another thing that hasn't really gotten much traction in constitutional jurisprudence, but it could be understood as an expression of this idea that all government is limited. Right? State government can do certain things, but the people, as individuals, retain certain kinds of liberties. And the Ninth Amendment may be an expression of that. And on this point, if you go back and look at Griswold, the Ninth Amendment is one of the places that Justice Douglas, in the majority opinion in Griswold, looks to in setting out these penumbral privacy interests under the Constitution. And Justice Goldberg in Griswold writes a concurring opinion, which is all focused on the Ninth Amendment, and says the interest here is really a Ninth Amendment that the people have against the state of Connecticut, which is trying to regulate contraception. Justice Stewart in Griswold writes this dissenting opinion in which he says, you must be out of your mind. I mean, how can it be that the Ninth Amendment is a limitation on the ability of the state government to regulate conduct? The Ninth Amendment is something that reserves powers to states and to people. But there is, I think, a plausible argument that the Ninth Amendment, in fact, is an expression of this Lockean idea of limited government. It's a libertarian idea, and I think that it's something that it will be interesting to see whether the court pursues it any further. Let me just finish up by saying a word about public opinion. The court in Justice Kennedy in Lawrence v. Texas is very much, and the court is very much a follower rather than a leader, right? There's really been a big shift from the time of Bowers versus Hardwick in 1986 in terms of how people in this country understand the status of gay people and same-sex relationships. Up until, I mean, it's a really seismic shift. We're now talking about the possibility of same-sex marriage, which was inconceivable in 1986 when Bowers was decided. So the court there has also been a shift taking off the books of many of the criminal laws in the states that prohibited same-sex intimacy. So the court is really, I think, taking notice of that. And some people look at that and say, well, it's really not appropriate for the court to be bending to public opinion, to be coming up with constitutional rights based on public opinion. But I think that this is actually an almost perfect instance of where it is not just appropriate but desirable for the court to be looking at a broader, national, sustained consensus and meditation on the meaning of liberty. And it's really to the court's credit that it's prepared to overturn Bowers versus Hardwick, in part on that basis, because there has been such a sustained national consensus that has grown up about the meaning of liberty in this context. So I went to law school in the 90s, which was a really dark period in constitutional jurisprudence. The cases that came out of the court when I was in law school were terribly convoluted it was the sense at the time that if you were somebody who cared about civil rights, if you were litigating these kinds of cases, the name of the game was to keep the case away from the Supreme Court. Getting cert denied was a victory in these kinds of cases because you didn't want that case going up to the Supreme Court for it to do all these strange things with liberty. So in that sense, this is it's a really promising time to be studying constitutional law. We're far removed from the civil rights cases of the 60s and from the privacy cases of the 70s. So this is a little bit of that sentiment, I think. So it's a great time to be in law school with the promise that the court has really given us in Lawrence v. Texas, and it's a great time to be teaching constitutional law. Thank you.
Thank you. If you have questions about the scope of Lawrence versus Texas, you're far from alone. Everybody in the country has questions about the scope of Lawrence versus Texas and what will happen next. We decided, since we wanted today to just give you an overview of some of the major issues that are before the court recently and coming up, that we will hold all of the questions on all topics until the end. We will give you an opportunity to ask questions and join in the discussion. But meanwhile, we want to move on to the next blockbuster case, brief introduction from the end of last term. Another new member of our constitutional law faculty, Professor Heidi Kitroso.
Hi. Well, I'm sure many of you have already read quite a bit about the cases coming out of the University of Michigan in the newspapers. Some of you might have actually taken a look at the cases. What I want to do here is just briefly start out by giving you the basic facts of what was at issue in each of the two cases, what was different about the two affirmative action programs at issue, because as many of you might already know, these are two cases that came out somewhat differently, based in large part, according to the court, on distinctions in the facts at issue there. Talk a little bit about the facts of each case, then I'll talk a little bit about the law that the court was purporting to apply in the cases, and talk about the results in the cases. And then I want to just say a few words for now as food for thought, and possibly flagging points for discussion later in this hour about some major issues that are raised in these cases, or questions raised by the cases. As far as the facts, there were in fact two cases that came out of two affirmative action policies at the University of Michigan. One of the cases, Grutter versus Bollinger, was a case that challenged the law school's affirmative action policy. The law school's policy, as characterized in the court's opinion, essentially was a relatively loose policy whereby race on the part of certain underrepresented minority groups was deemed by the law school admissions office essentially to be a plus factor, to be one of many positive factors that the law school said it considered when it was making admissions decisions. As far as whether the law school had any specific goals or targets or methodology for determining how it would take this plus factor into account, what the law school said essentially was that it tried to reach some sort of loose critical mass, was how it put it, of underrepresented minority groups. And there was some question, even as characterized in the court's opinion, as to what was meant by critical mass. But as the law school admissions office put it, and as the court seemed to accept, the basic idea was that the law school admissions office considered a critical mass of a given group to be reached if the law school had enough members of that group that individuals of that group, one, feel isolated in the law school, one, feel as though every time they spoke they were the voice of the race. A critical mass was deemed to be an amount whereby other members of the law school community perhaps could get past stereotypical notions based on knowing one or two members of that given group. So that was the policy at issue in Grutter, basically characterized as a fairly loose policy whereby race was considered, according to the law school, one of many potential positive factors. And as we'll see in a minute, that characterization was very important in the policies being upheld by the court. Then there was the Gratz case, Gratz versus Bollinger, which was a challenge to the undergraduate admissions policy at the University of Michigan. And there, the policy was characterized by the court. Well, the undergrad program had actually gone through several different policies, but the policy that the court was actually examining was a policy whereby each admissions decision was made on the basis of a 150-point scale. So you're a candidate, you're an undergrad applicant, you potentially could get 0 to 150 points. And within that point range, the undergraduate program or the admissions office decided to award 20 points for being members of given underrepresented minority groups. Now, certainly there were many other bases for potentially receiving points, for potentially receiving automatic points, for potentially receiving discretionary points, but that was the way points were allocated on the basis of race. So these two cases come up to the court. In terms of the applicable law, I'll put it simply for now, but underlying this legal standard are, of course, a lot of questions, and I'll try to flag a couple of those toward the end of the discussion. But the basic rule, or the basic sort of legal standard or doctrine that was applicable was the standard of strict scrutiny. And that is, as those of you who have already taken equal protection law know, whenever an equal protection case comes to the Supreme Court or to any court, the first and arguably perhaps the most decisive question that the court has to answer is what is the applicable standard of scrutiny that the court has to apply to the given program. And the basic idea is that the more pernicious the category, that is, if it's a category based on some factor that historically we in the courts have indicated they don't want the government to consider, like race, that the standard of scrutiny that's applied is very, very high. And so typically, whenever a categorization based on race is challenged, the court applies what's called strict scrutiny. That is the highest level of scrutiny, the toughest level of scrutiny that the government has to meet to justify what it's done. Now, there's a lot of controversy, and has been a lot of controversy over the years, about whether it's appropriate to lump affirmative action programs in with other forms of categorization based on race. The argument against doing this being, look, affirmative action programs are not seeking to disadvantage historically oppressed groups. Rather, they're seeking to sort of equalize and, in fact, further the cause of equality with an inherently unequal playing field. So is it really fair to subject these programs to strict scrutiny? I'll raise that issue again after I've talked about what happened in these cases. But in a nutshell, the applicable legal standard here was deemed to be strict scrutiny. So looking at these two sets of cases, what the court had to answer was, look, does each policy pass the threshold of strict scrutiny? More specifically, can each policy be justified by a compelling government interest, and specifically, can it be justified as being narrowly tailored to meet this compelling government interest? In terms then of how each program fared, essentially the law school's admission program was upheld under strict scrutiny in a panel consisting of O'Connor, Stevens, Souter, Ginsburg, and Breyer, whereas the undergraduate program was in fact held to be unconstitutional in almost the exact opposite panel, albeit with O'Connor switching sides so that Rehnquist, O'Connor, Scalia, Kennedy, and Thomas joined the majority to deem the undergrad admission program unconstitutional, and Justice Breyer also concurred, but he did join the majority opinion. And essentially the way the analysis went down in each case was like this. In the Grutter case, that is in the law school admissions case, the first thing that the court said responded to what probably was the most controversial legal issue in the case. And that is the law school had deemed their compelling government interest to be diversity, specifically an interest in having a diverse student body. Given the state of the case law prior to these cases, there was a very, very significant legal question as to whether, in fact, the court would deem anything but, say, remedying past discrimination to be a compelling government interest. So in the Grutter case, when the court said, in fact, diversity can be deemed a compelling governmental interest, will buy that part of the law school's argument, that was a pretty big deal. And then in terms of applying that to the rest of the legal standard and to the facts, specifically, is the law school's program an appropriate means, a narrowly tailored enough means of achieving diversity? The court again found that the law school's program was constitutional. One of the major things that the court emphasized was the flexibility, the looseness of the law school program. As I discussed before, the university had essentially characterized it as a program whereby race was considered among many other factors. There was no specific point value given for it. It basically just enabled the university, given their academic mission, given how important they deemed diversity toward this mission, to take this, among other factors, into account. And the court very much embraced this argument. They emphasized, among other things, that universities should receive some deference in terms of their interpretation of their academic mission. And again, they emphasized the looseness of the inquiry, saying, look, this really allows for very individualized, flexible inquiry. This is okay. As for the undergraduate admissions policy, the court's analysis, and again, as I said, this was a very different panel with respect to the Gratz or the undergraduate case, deeming that program unconstitutional. But the main thing that the court did there was explain why the nature of the undergraduate program was not acceptable, even assuming, in light of Grutter, that diversity is a compelling governmental interest. The court focused on the point value that was attached to race and said, this doesn't really allow for a flexible enough, individualized enough assessment. This is more in the nature of what the court referred to as racial balancing. It's somewhat closer to a quota, which the court has indicated isn't appropriate. And so that's how these two decisions came out, seemingly quite differently, although again, attempted to be reconciled by the court as simply distinct on their facts. Before I sit down, let me just say a few quick things about, basically just food for thought, maybe points for discussion later, about some of the major issues that these cases raise. First, the issue of the application of strict scrutiny to affirmative action programs. As I've said, on the one hand, that's fairly well settled now, but on the other hand, it's a pretty fair topic for debate. Certainly in the Gratz case, two dissenters, Justice Ginsburg joined by Justice Souter, as well as a concurrer, Justice Breyer in that case, raised the question as to whether it is appropriate to apply the same level of very difficult strict scrutiny to affirmative action programs as to other race-based programs. Second interesting question that's raised is whether how we characterize diversity, why we characterize it, why the courts characterize it as a compelling government interest, how we define diversity. And third, just considering the Gratz and the Grutter cases themselves, an interesting question is raised as to whether the distinction that the court draws between the two cases is a fair one. One point that the dissenters made in Gratz, in the undergrad case, is maybe the undergrad program is just being penalized for being more candid and for saying, look, you know, considering race isn't just some metaphysical exercise. Sometimes it might mean attaching point values to racial characteristics. So that's another question that's raised, even just taking the legal standards as given, whether the court appropriately treated the two cases differently. I've probably gone over my time, so I'll sit down now.
As Lawrence says, obviously a lot to be said about the affirmative action cases, and we never thought we would cover it all today, but what I am hoping is that various student groups will be interested in sponsoring programs as the year goes on about affirmative action, about the issues in Lawrence and whatever other. And now you know some faculty members who might be interested in helping if that's something you're interested in continuing the discussion on. Moving on from last term now to the new term. One other thing that's very unusual about this new term is that the Supreme Court, rather than waiting for the first Monday in October, had a kind of prequel. They had one early argument, as you're probably aware, on the campaign finance cases. And here to talk about those cases are resident expert, Dean Joel Gora, who was at the argument.
Thank you, Susan. Yes, the argument that the Supreme Court had last month was really almost unprecedented. It was the first time in over 30 years that they took a break from their summer vacation to hear argument in the case. The previous time had been when they were hearing argument in the President Nixon Watergate tapes case, which those of you that have studied constitutional law will remember. And it was also unusual. It was the first time in almost 30 years when they devoted not their traditional 1 hour to an argument in the case, but gave it the entire day, 4 hours of argument. The time that they had done that previously was the other campaign finance case, which many of you may be aware of, called Buckley versus Vallejo. I'm one of the few people who happen to be involved in both cases. I was joking with a couple of the reporters that had been reporting back in 1975 and 1976 about how few of us that were left still standing. I think I once referred to Susan, in a conversation with Susan about this case, as I felt like Captain Ahab. But I decided I would rather be Ishmael. At least Ishmael survives. Let me just, in a moment, briefly set the stage of what the case that the court heard last month entails. I'm going to read to you from the first page of the brief filed by the American Civil Liberties Union, and those of you that are familiar with the ACLU know that normally it provides counsel to represent the rights and defend the rights of others. But in this case, it itself is a party, because the ACLU feels that this law, in many of its applications, restricts the ACLU's freedom of speech and association and petition. So the ACLU is a party to the case, along with a number of other groups, a lot of strange bedfellows and odd couples. The AFL-CIO, shoulder to shoulder with the Chamber of Commerce, challenging this law. The ACLU, together with the National Right to Life Committee, with whom they agree on nothing else except the unconstitutionality of this law. The California Republican Party, together with the California Democratic Party, joining and challenging this law as well. So it's interesting. The statute is the Bipartisan Campaign Reform Act, and the attack on it was bipartisan as well. The brief says that the case presents a challenge to key provisions of the Bipartisan Campaign Reform Act, which impose new and unprecedented restrictions on core political speech in the guise of revising this nation's campaign finance laws. Despite its size and complexity, the BCRA, BICRA, was designed to achieve two principal goals. Title I prohibits the use of so-called soft money by political parties, even for traditional party-building activities, such as voter registration and get-out-the-vote drives. Title II, which which is the title that the ACLU and the other issue groups are challenging, makes it a crime for even non-profit organizations, membership organizations like the ACLU, to broadcast an ad that mentions the name of a federal candidate, just mentions the name, President Bush, in the period preceding an election. The district court correctly recognized that neither of these broad provisions could be reconciled with our constitutional traditions. It therefore declined to uphold the law that Congress had written. It nevertheless upheld a rewritten and narrowed version of the law that continues to pose severe constitutional problems. Because the ACLU is not directly affected by the soft money ban, we will leave it to others to explain why that prohibition on the use of soft money for issue advocacy and get-out-the-vote activity is unconstitutional. We do, however, have a very direct stake in the lower court's interpretation of Title II. If that interpretation is upheld, it will now be a crime for the ACLU to broadcast an ad on radio or television advocating its views on a particular civil liberties dispute if the ad could be construed as attacking, supporting, promoting, or opposing a candidate for federal office. To place that dilemma in more concrete terms, President Bush has just announced his intention to run for a second term. There have also been press reports that the administration may be seeking enhanced surveillance powers from Congress as part of a new legislative initiative. If the ACLU chose to oppose these steps on civil liberties grounds in a broadcast ad that referred to the president, we would be risking criminal prosecution based on the lower court's decision in this case. That result would drastically and dramatically transform the rules of political debate in this country and go far beyond anything this court has ever permitted under the First Amendment. The ACLU urges this court to reverse the district court and invalidate the challenged Title II provisions. Well, so those are the issues, and they are not just questions about campaign finance regulations. They really are questions about the very nature of the First Amendment itself and the role that it is to play in a democracy. The original case that dealt with those issues, Buckley versus Vallejo, split the difference. Those of you that have had a chance to study the case or otherwise are aware that what the court did there was to say that limitations on the campaign expenditures, on campaign speech, cut to the core of the First Amendment. Limitations on independent groups that wanted to criticize political officials, cut to the core of the First Amendment. Those were impermissible. On the other hand, the court held that limitations on contributions made to a political candidate were subject to a little lesser First Amendment scrutiny and could be upheld upon a lesser constitutional showing. And so that kind of Solomon-like decision set the stage for the law in the last almost 30 years. Expenditures are not limited, contributions are limited. And it was sort of a recipe for a number of things which, not surprisingly, have occurred. Number one, if you have resources of your own or know people who do, you're in better shape than if you're without resources. So the law favored speakers with resources over those without. If you were an issue group that wanted to criticize the President of the United States, like the ACLU, you were basically immune from any government regulation. If you were a political party or some other regulated group, you were not. If you were a challenger wanting to defeat an incumbent, the law made it extremely difficult for you to do so. If you were a minority party that was told that it had to disclose its members in order to inform the public about who supported it, you might face sanctions and harassment, and the court said you would be able to challenge those on a freedom of association ground. And so the situation was one that nobody was really pleased with. Although there was a great deal of campaign funding, there was not enough of the resources spread around, there was not enough speech to go around, if you will, and the question then became what to do about it. And for many years there were many proposals in Congress. Some, few of them, unfortunately a few, only a few, would have provided public financing and public subsidies for campaigns. But those were quickly defeated. I guess Congress didn't want to provide extra money for those people that would oppose it. And what was finally passed after several years of lobbying and discussion was the so-called McCain-Feingold bill, the Bipartisan Campaign Reform Act. As I mentioned at the outset, it does two things. It limits what political parties can do at the federal, state, and local level, even though what they're doing has only the most remote connection either to federal elections or to federal officials. And more importantly, from my personal and institutional standpoint, it limits the rights of independent groups, labor unions, corporations, non-profit organizations, membership organizations, individuals just citizens to criticize government and public officials in the period leading up to the election. There's a doctrine of torts, res ipsa loquitur. I always felt that the statute was subject to the same doctrine. The idea that it could be a crime in a country that has a First Amendment to run an ad criticizing the President of the United States struck me as at least probably a violation of the First Amendment. And that's the issue that the case is going to resolve. As I said at the outset, it's about more than just campaign finance regulation and the ins and outs of campaign finance law. It's really about the First Amendment. Yogi Berra once said, when you get to a fork in the road, take it. Well, the court is at a fork in the road. And it's really going to have to decide whether it wants a First Amendment that's basically a regulated industry First Amendment, or whether it wants a First Amendment that I think is more in keeping with what the framers wanted, namely one that ensured uninhibited, robust, and free debate on political issues. Thank you.
Thank you, Ishmael. We'll call you Captain Ahab. If you've been following Supreme Court previews and whatever your favorite source of news is, you know that most people are predicting that at this point the Supreme Court hasn't really taken any cases for this term that look like they're going to be any bigger than the campaign finance cases that they've already heard or than the cases from the end of last term. However, there are a number of significant cases that the court does have. There's another case in addition to the campaign finance case that's about political elections, and that's a case coming out of Pennsylvania called Vieth versus Jubilerer, V-I-E-T-H, if anybody's taking notes, as some of you are. And this is a case considering the question of whether there are any constitutional limitations on partisan redistricting. In Pennsylvania, seven of the 19 districts in the state are Republican-controlled, even though the state is roughly 50-50 Democrats, Republicans. I'm sure many of you have been following the adventures of the Democrats in Texas, who sometimes have not been in Texas, because they've been trying to avoid partisan redistricting. And this case could be extremely important because the Supreme Court will be telling us whether they think that there are any constitutional limitations on that phenomenon. Another tremendously important case coming out of Washington State is called Locke versus Davey. And this is a case about the tension between the Establishment Clause and the Free Exercise of Religion Clause in the First Amendment. The Supreme Court has previously decided a case about school vouchers, holding that the use of school vouchers may in fact be constitutional under the First Amendment. However, many states, like Washington State, have provisions in their own state constitutions, often called the Blaine Amendments, which prohibit the use of state funding for any religious organization. So what's happened in Washington State is that a young man who applied for a scholarship to become a minister, to really go and learn to practice his faith, was told that he could not get state-funded scholarship because he, in fact, was looking to practice religion, and that the state constitutional provision prohibited that. The question that the Supreme Court will be considering is whether Washington, in fact, is exceeding federal minima by doing more in terms of protecting preventing the establishment of religion, or whether this, in fact, counts as a discrimination against religion. Very important question, which will also have a lot of consequences in terms of future voucher programs. The court has 3 cases about federalism, continuing their inquiry about when states are immune from various kinds of suits in state court that I won't describe in detail, but they're there. They have 4 cases about constitutional limitations on interrogation, particularly cases following up on Miranda, that are also quite significant, and 5 cases about search and seizure limitations under the Fourth Amendment. And all the reporters are asking, well, why all this interest in Miranda and the Fourth Amendment? Is the court aware of the war against terrorism? Well, probably they are. So far, they've been denying cert on all the direct cases that have come up on the war and terrorism, several different cases. There's one case pending on their docket that they might grant cert on. Sooner or later, they're going to grant cert on something in that area. Plus, there are 2 other very big cases pending that the court has not yet decided whether to take. One is about whether it's a violation of the First Amendment for a doctor to be prohibited from telling his patients in California about the possible use of medical marijuana. It should be an interesting case if the court decides to take it. And finally, if the court decides to re-enter the culture wars, they could grant cert on the case out of the Ninth Circuit, holding that the Pledge of Allegiance, including the words "under God," is unconstitutional as an establishment of religion. They're still sitting on that one, and they've gone past a number of dates on which reporters have expected them to answer whether or not they're going to take that case, and they haven't yet decided, so you'll hear as soon as anyone else. Now, I think the natural segue from talking about what the Supreme Court is up to the topic that the Alliance for Justice has designated, judicial confirmation, is that these 9 justices, as history tells us, probably will not live forever. And at some point there will be a need to replace one Supreme Court justice. In the meantime, there has certainly been any number of battles over judicial confirmation over lower court judges. And here to tell us a little something about judicial confirmation, Professor Will Hellerstein.
Well, I think by now you appreciate that who sits on the Supreme Court is extremely important. And as Susan has mentioned, some of the members of the court are quite old. Chief Justice Rehnquist, who you might have seen the Times being helped down the stairs of the National Cathedral on Sunday, is not as spry as he once was, at least physically, but I have not noticed any deterioration in his ideology. Justice Stevens, who, although appointed by Republican President Ford, I think is holding out with the hope that if he, and he's quite old, he's well into his 80s, for a Democratic presidency, being the liberal wing of the court, the leader of it. And Justice O'Connor is always up for grabs. She's had some health problems, but she seems to be thriving as the person who controls the destiny of the country. And, even Justice Ginsburg, who has had some health problems, there is much hope that she will continue to be well. Judicial selection and confirmation, is it a sport? Yes, it is. It's a blood sport. And there has been an ongoing battle with virulence. Look, there have always been controversies about Supreme Court appointments, but the vitriol that infects the present process is traceable to President Ronald Reagan. And the battle as it currently rages, not only with U.S. Supreme Court nominees in the future, but with the current federal judiciary, the lower court, may last as long, I regret to say, as the War of the Roses. The question that I raise is whether it should be thus. I don't think so. I think the ideological struggle for every vacancy on the court since 1980, when Reagan became president, was unseen. It poses a threat to judicial independence and prevents the nation from having highly qualified men and women serve us as judges. Now, from day one, there have always been rejections of Supreme Court nominees. But prior to the 1930s, nominees to the court, when they were rejected by the Senate, was because of generally personal characteristics, incompetence, irascibility. There was no ideological litmus test kind of battle. It was not even customary for a nominee to appear before the Senate and be questioned. But there was one major battle in the 20th century, early part 1916, when President Wilson nominated Louis Brandeis for the court. And that battle was driven by a combination of the anti-Semitism leveled because Justice Brandeis was a Jew, and because he was not part of the white shoe corporate establishment. He was viewed by many as, quote, a people's lawyer who challenged some of the sacred cows of the day. The court crisis of the New Deal, of course, was a very serious matter, and President Roosevelt succeeded in replacing most of the 9 old men who constantly thwarted the New Deal program. But the nominations of justices like Douglas and Frankfurter, Reed, Murphy, Rutledge were not controversial because the Democrats controlled the Senate. The real controversy of that time was the court packing plan that Roosevelt would have liked to have succeeded on, that would have replaced every justice on the court who had reached age 70, would have added another justice, bringing the court to a maximum of 15. Even people who supported all of President Roosevelt's policies on the New Deal, many resisted that court packing plan. And that was really the last time there was any true controversy about nominations until President Nixon campaigned in 1968 against the Warren Court. And what was it about the Warren Court? Well, President Nixon was a very savvy politician, and he knew that some of the things that Warren Court had done, like Miranda versus Arizona, mainly in the criminal constitutional revolution, did not curry favor with the majority of the body politic. And so that became an issue on the election. He succeeded when Earl Warren retired in nominating Warren Burger. And then the next vacancy, he tried to fill with two gentlemen, Clement Hainsworth, who was the chief judge of the Fourth Circuit, but was not confirmed because of the strong movement by the labor wing of our country, feeling that his performance on the bench was not pro-labor. Then President Nixon nominated G. Harold Carswell from the Fifth Circuit. Well, he was defeated because he was a racist, because he was incompetent, and he wound up his glorious career being busted for public exposure in a men's bathroom. The problem with Nixon is he didn't really give a hoot personally about the court, and certainly not the lower federal courts. And so he nominated Harry Blackmun, who always referred to himself thereafter as Old Number 3. And as you know, Harry Blackmun, the author of Roe versus Wade and some other landmark cases, didn't quite fit the mold that President Nixon had hoped for, but he didn't really care that much about it. And he didn't really care about the lower federal courts, if you tracked his nominations. Until Ronald Reagan came in. In 1980, he campaigned against the appointment of a certain type of person or persons for any federal judicial post, including the Supreme Court, and really imposed a litmus test. He declared war on liberal activist, quote, judges. And I must admit, and I guess in the interest of full disclosure, I should tell you I'm Exhibit A, would be, because in 1984, when Reagan was president, I was nominated by Senator Moynihan to sit on the Southern District, despite endorsement of 27 U.S. attorneys, not known for their Trotskyite leanings. The president would not send my nomination to the Hill because I had offended in the fact that I was a legal aid lawyer for 20 years. And so it was. Despite that, I think I can approach the subject with some objectivity. And I feel you should know that about me. But all of these were skirmishes until Lewis Powell, Justice Powell, resigned from the court in 1985-86, and President Reagan nominated Judge Robert Bork. And not only was he defeated, but he added a piece of English language to our dictionary, to be borked. Now, he brought to the table tremendous credentials. Law professor again, expert in antitrust law, federal appellate judge, a solicitor general of the United States, and he was brought down to defeat. Why? Well, Powell held the keys to the kingdom, it was perceived, on the issue of abortion. And as a professor of law, Judge Bork had written an article way back in the Indiana Law Journal thinking that Griswold, let alone anything else, was an illegitimate decision. But there was more to that, and he was defeated by a vote in the full Senate that divided along party lines. And life has not been the same ever since. So fundamental questions are raised. Who should the president nominate? What should go into his judgment? And what is the Senate's role? Should there be a litmus test for a nominee? What should a person's qualifications be? How much can be demanded of a nominee in terms of giving his or her position on substantive matters that could come before the court? Are we paying too high a price in terms of acrimony? Are we losing very qualified people who won't even seek judicial office because of what the process has become? Can we bring the process to some greater degree of balance and stability, I would say, than we have now? My own view, not to put too fine a point on it, is the process has been overly politicized by the Republican Party. Our current president is clearly replicating the policies of President Reagan, even more so than his first President Bush, who I think was more like Nixon, didn't really care that much. Question of degree. But I think W is doing it with a vengeance, and he has a good accomplice in our current Attorney General. And what is that nominee supposed to look like? Well, he ain't look like me, and he ain't going to look like a lot of you, or she. Essentially a right-wing conservative, and that is why the wars that are ongoing, as long as there is no vacancy on the Supreme Court, affects people who are nominated for the lower federal courts. And he has left the Democratic Party with little alternative but to wage a strategic holding patterns by trying to pick off. They can't pick off everybody, so they pick off those who they think are most worthy of picking off. And I think it's unfortunate. One fellow who was picked off, who I happen to admire greatly in terms of his skill and his ability, we may not share the same views, but I've worked with him on a capital case, is Miguel Estrada, who you have read about. He was nominated for the D.C. Court, which everyone believes is a stepping stone to the Supreme Court. Despite his qualifications, his nomination was defeated because of the ideological battlefield that the process has become. The question is, should we continue in this vein, or try to bring it back to a more central stage, a more balanced approach, where people's qualifications, remember, the judiciary should be independent, and to require a commitment from nominees that you will adhere to the party line, I think does a great disservice to the process.
I know a number of you have 2 o'clock classes to get to, but we have reached the point where you are invited to ask questions or make comments. I think we've given you a whole lot of grist, any number of topics to talk about. So while people are getting to their 2 o'clock classes, who would like to start off with a question or comment? Anything? Yeah.
In the affirmative action case, there was a comment, I think it was by O'Connor, I'm not sure, but about how in 7 to 10 years, affirmative action wouldn't be necessary anymore, and that was really criticized in the media as policymaking as part of the court. What are your thoughts on that?
Well, no, actually, I'm glad you mentioned that. That was one of the points I wanted to make about what the majority said in Grutter. You're right, it was Justice O'Connor writing for the court in the Grutter case who made an interesting statement toward the end. She said, look, right now, in order to achieve the compelling interest of diversity, essentially what she was saying is it's quite conceivable, giving appropriate deference as the court deemed it necessary to the university in light of social realities. It's essentially just quite conceivable to say, look, we need to take these extra steps given what society's like right now. We need to keep adopting affirmative measures in order to achieve what the school calls the critical mass of giving groups at this point. But then O'Connor made the point that, look, we've always said, we've always expressed our hope that any sufficiently narrowly tailored affirmative action program is going to be limited in time, given that the idea behind the programs are essentially to make up for problems in our framework of social equality. And so O'Connor made the point that, look, we would expect in, say, 25 years that affirmative action admissions programs will no longer be necessary, hopefully as society continues to change. And some points that were made in concurrence were that, 25 years might, if anything, be somewhat unrealistic, considering how long it's taken this country to deal with intractable problems of inequality, etc. As far as the point you raised, though, that got some criticism as being policymaking, certainly, one could see where that point would come from, to say, well, gee, where is she getting 25 years? That sounds like legislative policymaking. On the other hand, though, to be fair to Justice O'Connor and to the majority that signed on to that position, I think that she did couch the point, and I think fairly convincingly, as being part of this narrow tailoring question. That is to say, look, it's not enough you have a compelling governmental interest. Assuming that strict scrutiny applies, The measure has to be narrowly tailored toward that end. And so essentially you characterize what O'Connor and what the court was doing in Grutter as saying, look, part of the narrow tailoring inquiry is to see if the program is limited in time. I think probably what's most subject to criticism about the 25-year statement is that 25 years, reading the opinion backward, forward, sideways, it did seem pretty arbitrary to me. And that is, again, a point some have made that, look, even assuming a time limitation of some sort is appropriate, maybe something more like a case-by-case every few years, looking at the program is more appropriate than just picking an arbitrary number. Justice O'Connor seemed to get the number from looking back to a case called Bakke, which had been the major Supreme Court case on affirmative action in higher education prior to these cases, and that case was decided roughly 25, 26 years ago. So Justice O'Connor said, well, look, it's been 25 years since Bakke. We expect in 25 years these programs won't be necessary anymore. Having said that, though, it certainly in the way that that point was framed, it didn't look like it was a really technical part of the holding so much as it was a sort of hopeful suggestion that we may revisit this issue, if not in this case, in another case, and at some point say that time has passed at which we can say programs are narrowly tailored to achieve diversity.
Other questions or comments?
When the president rejects a judicial nominee, does he have to give his reasons?
Nope.
Not at all. Okay.
And are there any ideas or plans in the making for how to control the judicial nomination process?
Not to my knowledge. I'm not so sure they should be.
Maybe some of the other panelists would like to comment on suggestions.
Well, I mean, I've actually written a little about this. I mean, one of the problems is in order to get beyond the current situation, you really need a bipartisan commitment to fixing things. I mean, in the Senate, you need the Senate to come up with a series of rules that it's going to abide by in terms of treating judicial nominees. The problem is how do you get senators to do that? I mean, unless you have an absolutely equal split 50-50 in the Senate, which you almost have now, but you don't quite have it. There's really not a whole lot of interest in with respect to either side in terms of doing that. So it's a bit of a problem in terms of getting to any kind of reform. If you had sort of more far-sighted senators, then perhaps it would be more hopeful. But it's hard to know what kinds of reforms are ever going to get put into place anytime soon.
Just to follow up on that, I think it's a delicate balance. We say in studying constitutional law that since the Supreme Court's decisions are final, there are very few ways to correct them. If the country thinks they're wrong, you can amend the Constitution. That takes a lot of activity. But one sort of check on the court is the political process. If you don't like Miranda or Roe, then you elect the president and senators who will nominate judges who have some questions. And it's like an ongoing dynamic. I think the problem is when you spend too much time inquiring how particular candidates or nominees feel about specific cases and issues, you really do threaten the independence of the judiciary. Because if the judiciary is just simply going to be a reflection of majority rule, then what's the point? I mean, they're supposed to protect minority rights. So it's really, as I said, a difficult balance. I must say, I found it a little troubling when 2 years ago when the Democrats, particularly our own Senator Schumer, launched an overt campaign to investigate the ideological views of judicial nominees. And he said, I want to know how they feel about gun control, I want to know how they feel about privacy, and I want to know how they feel about campaign finance reform. As if to say, I'm not going to nominate or vote for anybody that's not going to come out the way I want on these constitutional issues. Well, I think you have to have a little independence.
And so it's definitely not on both sides.
Yeah, well, I think so too. And I don't know how to break out of I think that's a real problem. But we have, Will mentioned Miguel Estrada. We have someone who just everybody praised to the hilt as being a wonderful lawyer and a wonderful person, rejected because it's felt that if he ever got on this court, he'd go to that court, and then he votes overturn Roe v. Wade. It seems to me that's
One or two last questions or comments?
There was some discussion earlier about the role of public opinion in Supreme Court decision making, and I wondered if you could just discuss if that came up during the arguments.
well, it came up a lot, somewhat in the briefs. I think briefs of the parties defending the laws said, the public really wants these laws. There's a sense that the there's too much corruption, that the ability of the average person to influence politics has been undermined severely. Public opinion polls show that. There wasn't quite so much of a sense of that in the Supreme Court, because I don't know that they want to appear as if they're following public opinion. I mean, they're supposed to apply a compelling interest test to free speech questions, and I'm not sure that the fact that public opinion favors a point of view or favors a law will be enough to do it, to justify holding it. But I do think, and this was a comment made in the press over the weekend, in a way, the kind of court doesn't so much lead the public as follow. I mean, I think when major business corporations and retired generals and CEOs of conglomerates filed briefs in the Supreme Court supporting affirmative action and basically saying, you know, we couldn't do what we do without it. It's essential to business. It's essential to the military. All of this. That was really the establishment speaking. And so the court was really, in a way, sort of following the establishment and putting its imprimatur on it and kind of codifying what the culture had sort of already decided.
What I was really looking for in Lawrence was something that had been developed over many years, and it was clear that there was something deeper going on than simply a poll. There was a broader national sustained consensus, and that may be a more appropriate source for the court in determining questions like what is the proper scope of liberty than simply relying on the most recent opinion polls.
Yeah, that's what I was referring to too when I said cultural. And I think the point was the court had felt that the culture had become comfortable with gay rights, become comfortable with affirmative action as partly manifested in the briefs that filed with the court, but also the court's own sense of citizens of what's going on.
And let me just look at the other half of it. I think the Warren Court tried to lead, but misread the temper of the country, and that's what got it into political vulnerability. Since it did so much of its work in the criminal constitutional field, the rights of criminal defendants, given the velocity, the temper of those times, the Vietnam War, demonstrations, the combination of that, where the court was spewing out many, many decisions to defend criminals rather than showing sensitive victims, I think maybe it pushed the envelope too far and made them sort of a vulnerable issue in the 68 election.
We have one last question or comment from you over here.
I mean, mightn't there be a relationship between a reduction in campaign, a relationship between campaign finance reform and a reduction in very specific interest group contributions to candidates and the sort of litmus tests that are implied in judicial nominations? I mean, don't large contributions from like the ACLU, doesn't it just follow that you would then be beholden to the ACLU to only vote for a certain candidate?
We wish. That's the person I don't know the ACLU call it fat cat. The ACLU doesn't make contributions. And most of the groups involved don't make contributions. What they do is they speak out on issues. Now, the speaking out might work to the benefit of one side or to the detriment of the other side in a political sense, or partisan sense, but that's not why these groups do it. So I'm not sure that really sort of solve the problem. And in a very real way, membership groups particularly, like the ACLU, like the Sierra Club, like the International Rifle Association, they're sort of, they amplify the voices of all of the people that give $25 to become a member and want those groups to speak on their behalf. So I think that's a good thing.
Oh, I just wanted to add one quick point, sorry, about sort of the last line of debate prior to this question about campaign finance. I think one thing, and this has been somewhat reflected in the comments already made, I just want to extend the point a bit further. One thing that is really complicated about this issue of judicial independence and the notion that none of us certainly would endorse the idea that the judiciary is another branch that's just supposed to be directly responsive to the majority, is that sometimes I think a fair argument can be made that there are instances in constitutional deliberation where real changes in society actually might have legal significance. I think this is part of what Professor Mazzoni's point was getting at with respect to how changing conceptions of what is part of human dignity, what is acceptable behavior, might actually factor in reading a very, very flexible, hopelessly difficult and unclear document to what's meant by due process, to what's meant by equality. Someone like Robert Bork, who's largely known for his expansive reading of the Constitution himself in a book called Tempting of America, actually made the point that Brown versus Board of Education, the landmark desegregation case, was justified, as he saw it, not on the basis that the court actually decided it, but on the basis that over the years our understanding of what equality means has changed, so that even if segregation would have been acceptable to the framers of the 14th Amendment, it's not acceptable today. Similarly, the question about the 25 years point in the Grutter affirmative action case speaks to how changing conditions might affect the way we apply law to the facts. So it's very, very complicated. I think one thing that's tough about judicial confirmations and how cynical it might tend to make the public is that I think it's hard for people to find that distinction between where reality might be an acceptable thing to factor into decisions sometimes as a legal matter versus what it means for the court just to respond to whatever the majority wants right now.
Okay, well, thank you all for coming. Thank you for the public interest guru of the Career Center for putting this together.
Well, and I want to thank the entire constitutional staff, and especially Professor Herman, who organized the entire event. And thank you all for coming.